again, guys. This is Merideth Nagel here with our Homeschool for Realtors. And today we're going to talk about listing a property if the owner has passed away. Now, some of you might say, I think I might have seen a video about this before, and you would be right. We've talked about it before, but we continue to get questions on the subject, so I want to review it now. For those of you who haven't seen it, this will be a good first watch, and for those of you who saw the last one, please watch this one again. I'm going to try to address the specific issues that come up that we see that we continue to have questions on. Now, first of all, make sure when you go to list the property, you know who the owner is. And you determine that by going on the property appraiser's website and looking at the deed that you can click on there and see who is entitled to this property that you want to list, because that's the first place that you might notice that the name of the person on your listing appointment is not the person on the deed. That's going to be your indicator that somebody has passed away. So when you're at the listing appointment, there's a couple of things that are super important that you're going to need to address with them at the outset. Number one, find out who the person is in relationship to the person who has passed away. Is it their spouse? Is it their child? And once you know that, then figure out on what authority they're going to list the property. So if there was a deed of Merideth and Leon, that's my husband and wife, and at the listing appointment, only Meredith's there, and you ask where Leon is, and that she says that he's passed away, you're probably going to be okay. You can just proceed with her because she was listed on the deed originally. But if she wasn't on that deed, or if it was a child or other beneficiary that wasn't on the deed, they don't have an automatic right to list that property. A lot of people think they do because they have a power of attorney in hand. It's very common as people get older that they provide to their children and others that they trust a power of attorney that allows them to handle their business while they're alive. That power of attorney works great, again, while that person is alive. Unfortunately, at the moment of death, the power of attorney ceases to be effective. And so there is no right for someone who is named in a power of attorney to list that property. So you got to go look further. The questions you're going to want to ask are, well, has a probate proceeding begun? Now, if you get that question and you get a puzzled look, the answer is probably no. If a probate has started, they'll know that term because they will have gotten it from the lawyer. You're going to want to talk to them about the importance of getting that probate process started, or at the very least speaking to a lawyer to get it started, because again, they're going to have the legal authority both to sign the listing agreement and go ahead and go to closing. Now, I'm going to throw a wrinkle at you guys that you need to know, because this is coming up and I don't want you to get caught the last minute. If the property was the homestead of the person who passed away, so in our scenario, let's give an example. A daughter is named as a personal representative of the estate, and she tells you, I've got a probate attorney, no problem. If you should ask them, is this the house where your mom or dad lived when they died or owned when they died as their residence? And if the answer is yes, that means you're going to have to deal with that property as homestead property, which typically means that all of the siblings, if there are any, are going to have to sign a deed at the end. I do not want you to start giving legal advice at that point. When that information comes across your desk or in the conversation, I think the best thing to do is call me or another realtor. I will answer your question any time of day, whether you close with me or not. And I can walk you through what the next steps might be if it's a homestead property. What's super important to remember is a listing agreement that's not signed by the right people is not binding on anybody. So in our scenario, let's suppose it's homestead property. And let us suppose that you thought you were doing okay because the person who signed your listing agreement is the personal representative in an estate. So you think, okay, I've got it. Merideth, there's a probate. They're the personal representative. Surely that'll be enough. Well, if the property is homestead property, then it's going to go to the children, generally, will go to the children of the person who passed away. So that could be the personal representative, but it will include her brothers and sisters. If those people don't also sign your listing agreement, then that listing agreement is null and void, and any of them can come in at any time and say, hey, I want my own realtor. And now you've just spent all that time and money marketing the property. So it's super important you get these questions answered at the outset, so that you can make sure that you have an enforceable listing agreement. It's also important to get these questions answered at the outset, because those people are going to have to sign the deed at closing as well. And sometimes we have situations where we go to the closing table and nobody knew it was homestead, and now all of a sudden we've got to track down brother and sister to sign a deed, and if they're hard to get or hard to get along with, the closing might not happen. You have a title problem, and the contract will cancel. So I just can't emphasize enough how important it is for you to know at the time the property is listed, what is the legal status of the person that you're dealing with. So just to recap again, power of attorney dies when the person who gave the power of attorney dies. There is no authority to list a property for a person who passed away just because you have a power of attorney. If a probate has not been started, you need to talk to your client about getting that probate started, because you're not going to be able to sell the property until the probate starts. And then finally, if it's going to be homestead property, if it's the homestead of the person who passed away, then you might have other parties that you're going to have to deal with. At that point, again, reach out to me or another real estate lawyer who can guide you and your customer through that process so that you can make sure that expectations are clear. Now, I do want to again emphasize, I mentioned this at the beginning, I want to say it again. None of this analysis applies if the deed on itself says who gets the property when the person dies, right? So if you have a deed that's with a joint tenants with rights of survivorship, then you don't have to go through the process. Whoever lives can sign the agreement and the contract and then the closing documents. So if that's your situation, you don't have to worry about it. Similarly, if a husband and a wife own a deed together, but it has to say as husband and wife, then again, the property is going to just go directly to the person who survives, and that's the only person that you need to deal with. So hopefully this has been a refresher for some of you, and then a helpful new information for others. As always, if you have any questions or problems or issues about anything related to real estate, please feel free to call me. I'll talk to you for free, whether you close with me or not. I just want to help you do the best you can with your real estate practice. As always, we can be reached at 352-394-7408. And thanks again for listening. I'll see you next time.